As a criminal defense lawyer who represents minors in juvenile court, one question I get all the time is, are the police allowed to question my child, my juvenile minor child, without me present, without the parents present? And unfortunately, the answer oftentimes is yes. If the police arrest a minor or detain a minor for a crime, they have to advise the child of their Miranda rights. But if the child gives up those rights and voluntarily agrees to talk to the police, then the police are allowed to question them and interrogate them. And quite often their statements can be used against them in court. However, there's two very important points to consider. First of all, I advise parents, educate your children about being questioned by the police. Instruct them that if they are ever detained, arrested, questioned by the police where they may be the suspect in a crime, don't agree to talk to the cops. Tell the police, look, I want to have an attorney and my parents present before I speak with you. Secondly, even if your children have talked to the police and maybe made a confession or admissions that the prosecutor or the police are trying to use against them, many times we can go and look at what the police did and get those statements thrown out of court. Because the police may not have properly advised the child of their Miranda rights. The police may have used coercion against the child. And I'll give you an example. I had a case not too long ago that was out of Rialto in San Bernardino County, where my client and a co-defendant were 16 years old. They were both charged with attempted murder, and they made what appeared to be a videotaped confession to the Rialto police. But we found that the police threatened them with the death penalty, made all sorts of coercive statements and promises that were totally inappropriate. So we had a hearing before the judge, and we demonstrated all this to the judge. Ultimately, the judge excluded those minor statements from evidence, and the entire case was dismissed.